Okay, guys. I'd like to call the Finance, Ways and Means Committee to order for April 23rd, 2024. Mr. Clerk, would you please call the roll?
Representatives Barrett, Boyd, Camper, Cochran, Crawford, Faison, Freeman, Gant, Garrett, Hawk, Hicks of Hawkins, Hicks of Washington, Kiesling, Lamberth, Love, Lynn, McKenzie, Miller, Moon, Parkinson, Shaw, Sparks, Whitson, Williams, Zachary, Vice Chairman Baum, Chair Lady Hazelwood. Madam Chair, you have a quorum.
Thank you, Mr. Clerk. Do we have any personal orders or announcements? Seeing none, we have 3 bills on our calendar today. Item number 1 is SJR 848 by Representative Stevens. You have a motion and a second. Representative Stevens, you're recognized.
Thank you, Madam Chairman. This Senate joint resolution urges the state to develop a comprehensive statewide paid family caregiving policy and program in collaboration with consumers, stakeholders, and advocates to support family caregivers in Tennessee.
You've heard the sponsor's explanation. Do we have any questions? Question. Question has been called on the resolution. Great catch there, Chairman Hicks. Without objection, we are voting on SJR 848. All in favor, please signify by saying aye. Any opposed? The ayes have it. SJR 848 goes to calendar and rules. We are, the next item on our, first item on our addendum calendar is House Bill 2310. We are going to roll that to the Hill. And we are going to proceed to item number 2, which is HB 1872 by Representative Fritz. I have a motion and a second. Representative Fritz, you're recognized.
Thank you, Madam Chair and committee. I bring before you HB 1872, which very basically does 4 things. I'll try to speak a little bit slower this time so I don't miss something. But those 4 things that it does, it addresses, I'll start with the school safety. Any adult in the state of Tennessee that goes onto a school campus while children are there and commits a violent felony crime is subject to a sentence enhancement of up to life in prison without parole. Secondly, illegal aliens who commit violent crimes in the state of Tennessee would be subject to that same sentence enhancement of life in prison with no parole. And then thirdly, illegal aliens who commit a crime and display or use a deadly weapon in commission of that crime would be subject to that life in prison enhancement. And then fourthly, this bill allows the magistrate or judge granting bond or bail to consider residency status of the person to whom the bail or bond is being granted. I would offer, Chair Lady and committee, that these are necessary. Unfortunately, in the day that we live, we have to consider opportunities to deter violent crime in our schools. I think this bill does a good job of that and offer that with the problem that we have at both our northern and southern border today in America. Human beings, as I said in previous committee, come across that border. Human beings created in God's image, just like each and every one of us. But some of those come with malicious and felonious intent. And I think this bill sends an absolute message to them. Don't bring that violence to the state of Tennessee. And with that, I would take any questions, Madam Chair.
Representative Shaw, you're recognized.
Thank you, Madam Chair. To sponsor, would this not just include anybody committing a violent crime? I noticed at the beginning you said anyone committing a violent crime may be in knowing it, but then you went to the legal aliens. But would this whole thing not just include anybody committing a violent crime?
Representative Fritz.
Thank you, Madam Chair. Thank you for the question. For the violent felony crimes committed on our K through 12 campuses, it is any adult, sir. As far as the other 2 areas, it addresses specifically illegal aliens in the state of Tennessee.
Chairman Whitson, you're recognized.
Thank you, Chair Lady. And I like that part about the schools and the violent crime. But let me ask you, and we may have to go out of session. if we put in there about illegal aliens and enhance their criminal penalty, could that be a constitutional problem? I don't know. And I would hate to see the bill fail because of that question.
Are you asking to go out of session?
Yes, ma'am.
Without objection, we're out of session and we will go to our legal counsel. Mr. Hayes, you're recognized.
Joel Hayes, Office of Legal Services. Chairman Whitson, as drafted and as amended by the previous committee, House Bill 1872 does have some constitutional concerns with it. A couple of them being under the 14th Amendment, whether or not there's a due process, an equal protection, potential equal protection issue, as the 14th Amendment states that nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws, because it seeks to punish undocumented immigrants more severely than other persons convicted of the same crime based solely on their immigration status and their national origin. That is in line with U.S. Supreme Court case with, I believe it's Plyler versus Doe, in which undocumented immigrants are to be essentially treated or considered the same as other citizens under equal protection and the 14th Amendment. Additionally, there's a question of whether or not this raises Eighth Amendment concerns as potential cruel and unusual punishment, because part of it, there is the possibility of the enhancement factor of life without the possibility of parole for what is considered to be a violent offense or a conviction of a violent offense. But that definition of violent offense has some Class E felonies, including offensive reckless endangerment committed with a deadly weapon, which is essentially brandishing of a firearm, could lead to the potential disproportionate punishment of life without possibility of parole. Some of the other offenses that could be included might be sexual battery is one of the offenses as well, which can be as simple as intentional touching over the clothes of a person without consent. That could also lead to a sentence of life without the possibility of parole.
Right. Thank you, Mr. Hayes. I do have some questions for you, I believe, while we're out of session. Representative Garrett.
Thank you very much. Thank you for those comments. When was the case you were referring to from the Supreme Court? When was that case decided?
That was in 1982.
1982. So the court looks very different between when 1982 than it does now. Would that be an accurate statement?
Yes.
All right. Thank you very much.
Representative Freeman. No. Representative McKenzie, were you wanting to ask of legal?
Yes. Thank you, Madam Chair. To you, I guess, two of the things that you discussed, having life without parole, are you saying the touching of a person without permission, with or without clothes, does it say intentional touching of a person or just touching of a person?
Mr. Hayes.
Representative McKenzie, I'd have to actually look at that statute if you could give me a moment.
Okay. And while you're looking at it, I'm asking because that's a very extreme penalty if it wasn't an intentional act.
As a criminal offense, there should be some type of knowing requirement as to whether or not it's knowing or intentional. That's what I would have to look at.
Okay, and then my second question on that one, while you is, again, I'm no lawyer, but I think we've got a great country since '82 and now, so I respect what our courts say then and now. Brandishing of a weapon. Does brandish mean displaying, or does brandishing mean pull out with the intent of using?
Mr. Hayes.
Again, that's another thing I would actually have to look at the specific wording of that statute, if you can give me more on that as well. Representative McKenzie, for the offense of sexual battery, there are 4 different types. But basically, the one that was described was that sexual battery is unlawful sexual contact with the victim by the defendant or the defendant by a victim accompanied by any of the following circumstances. Force or coercion is used to accomplish the act. The sexual contact, and I think this is what I described, the sexual contact is accomplished without the consent of the victim, and the defendant knows or has reason to know at the time of the contact that the victim did not consent. So there is a knowledge requirement in there.
Oh, so to my last question, if 2 folks are at a party dancing and let's say the guy touches during the course of dancing and it was not wanted or he didn't, but he touches the partner that he's dancing with, that could be, could fit that category. So thank you.
Chairman Hawk.
Thank you, Madam Chair. And of Mr. Hayes, to your knowledge, does this bill have a severability clause in it? And therein, what is the purpose of a severability clause? Thank you.
Mr. Hayes.
Section 4.
Chairman Hawk, this does have a severability clause in Section 4 of the amendment as it was amended in the previous committee. And essentially, the purpose of a severability clause is to, as it states, if any provision of this act or its application to any person or circumstance is held invalid, then the invalidity does not affect other provisions or applications of the act that can be given effect without the invalid provision or application. And to that end, the provisions of this act are severable.
Do I have any further questions of legal while we're out of session? Chairman Whitson? Without objection, we are back in session and we are back on the bill. Representative Fritz, you're recognized.
Thank you, Madam Chair. Just touch on a couple comments. I appreciate legal because I do agree with the iron sharpens iron approach to anything that we're doing. But let's think about the schools for a minute, K through 12 schools. Do we want to allow, this wasn't at a party that the touching took place. This would be on the campus while children were there. And I think for me, that certainly merits an enhanced penalty. I would also offer, I certainly, as my colleague from Knox County, my friend from Knox County said, I am not an attorney, but our Constitution was written for citizens, not the world. With that, I'd yield any further questions.
Representative Garrett.
Thank you, Madam Chairman. Thank you, Representative French, for bringing this piece of legislation. And not to agree or disagree with anything that our legal department says. You ask a question to 10 lawyers, you're going to get 12 different responses, and they're going to all be different, right? I mean, that's just kind of the way this works. We've got a case that we quoted from 1982. It's a 42-year-old case. We've got an administration that, you know, not only doesn't care that our borders are open, but also encourages it, and wants, and it is on the bill, and wants the. So what does states like Tennessee? What does states like Tennessee do?
Objection noted. Representative Garrett, please continue on the bill. Thank you.
What does states do when we're not necessarily a state that's on the border to curb and deter from illegal aliens coming into state Tennessee? What's happened is that every state now is a border state. So for there to be an issue of whether or not we have a piece of legislation that you're bringing to curb illegal aliens from committing crimes and making those offenses a little bit harder to deter that activity, you know, that's a question that needs to be answered from a case that's 42 years old. It's a widely different court that we have at the Supreme Court, and if this should be challenged and go up, I'd like to know what the current court would think, that we have policies in place by our federal government that encourages folks to come here. There's no other country in this world that allows this kind of invasion for folks to come into the state, come into the United States, et cetera. So I think this is a problem that has to be addressed. And it's going to be addressed in all forms of the government, all branches of the government, including our judiciary. So I look forward to voting in favor of your piece of legislation, even if it's challenged, because I believe it's time that we look at this at the present time that we're in, that it's okay and encouraged for anyone and everyone to come into our country. That needs to stop. So I appreciate your legislation, and I look forward to supporting it.
Representative McKenzie, you're recognized.
Thank you, Madam Chair. You know, as we sit here, passing laws or not passing laws, it's amazing how these timelines just get so misconstrued. We have a Bill of Rights that's way older than 42 years old that we stand by. Every word of it. Wildly different courts do things. So what we're potentially doing here by saying, well, it's 42 years old. Hey, we got a different kind of Supreme Court. Yeah, we had it in the 1800s as well. And in the early 1900s as well. You live by the law of the land. I won't say heavily compensate, but we compensate our legal department. That's their job. That's not our job. So a question was asked of the people that we're paying to adequately represent us. And they do a great job. So I'm offended at the fact that 12 lawyers, no, these are the ones that we're paying today. These are the two right now that we're paying at this moment. So I'm listening to them. And they're giving us data not based on conjecture of 42 years old and having a liberal or conservative court. They're giving us what is written. Laws that we apply 100 years, some last 100 years, some last 20 years, some last 2 years, whatever. But when we ask a question and it's not answered the way that we don't want it to be asked, now you question their virility. So to the sponsor, hearing that this piece of legislation will probably, on several accounts, cost the taxpayers of the great state of Tennessee thousands, if not hundreds of thousands of dollars to defend a bill that we were told before we vote is most likely not constitutional based on 3 levels. Why would you continue to push this legislation?
Representative Fritz.
Thank you, Madam Chair, and thank you for the question. I appreciate that. It'd be for your freedom, sir, that I continue to do this fight. Because in our Constitution, our Tennessee Constitution, we are called out twice with the word invasion. Our founders and framers of this state recognized fully that there was a potential for invasion of this country. Now, that's an inconvenient fact for some of the people that don't want to think that way, that it might be difficult for them to think that another human being might want to come into this nation and do harm to Americans, to Tennesseans. And while that may be an inconvenient fact to some, I take that very serious, that these Tennesseans, I swore an oath to uphold, including you, sir, all of Knox County, Roane County, and Loudoun County, to defend you, even when you don't recognize that it is the right thing or the necessary thing to do. I have sworn that oath, and I will, my friend, continue to defend your rights, your liberties, and your freedom.
Representative McKenzie.
Thank you, Madam Chair. Thank you. And we are friends and will continue to be. That's the great part of this body, that we can do that in most cases. My point is crime is crime. Now, the legal factor, if you want to create a piece of legislation that says you're charged, and they're out there with being illegal in this country, I agree. But what I don't agree with is rape, whether they're from East Knoxville or Rockwood or 10 Mile. Brandishing of a weapon is brandishing of a weapon. If we want to enhance the penalties, which we do every year, then we should do that. The crime is the crime, and it's horrific, and that's what we deal with. But to say, I'm going to charge this person harder than that person because of your immigration status is wrong. Let's enhance all of it. If it's bad crime, let's go after them. But to say that you get life without parole because you're not from this country, no, let's deal with you not being in this country. And we've been trying to get folks to do that for a long time on both sides of the aisle. And so let's deal with the part that needs to be dealt with. But to say that your rape is worse than another rape, your assault is worse than another assault, that's not the American way. That is not the America that we live in. The crime the punishment should fit the crime regardless. Skin color, national origin, or legal status in this country. This bill goes counter to that. And that's what we heard our lawyers say. That's not the American way. That's not the Constitution that we've been writing about. So again, I'll ask you, why are these two crimes different? And why would you pursue this piece of legislation? That's all I have. Thank you, Madam Chair.
Representative Fritz.
Thank you, Madam Chair. I'll try to be brief with this. Thank you again for the question. Again, it is for your freedom. It is for my grandchildren. It is for our grandchildren and our kids that live in this great state. It is our obligation to defend. It is our obligation, our sworn obligation to do so. And I don't think there's anything in the bill, and since I wrote it, helped write it, I'm certain it's not there about skin color or eye color or anything like that. But it's immigration status. And we are citizens of the state of Tennessee, all of us that sit here, and we're citizens of these United States. And we're not differentiating on that person by any status other than their illegality. They broke a law by being here illegally. Those folks that were about to be dumped in Dyersburg Saturday, Dyersburg, Tennessee, had broken the law by coming here. And then to the part of the bill that we seem to be ignoring in the questioning, our schools, our K through 12 schools, I'm committed. My little grandchildren need to go to a school where that we will accept none of these violent crimes, none. Whether it's the rape, sir, that you mentioned, or whether it's the touching or fondling or anything like that. I have absolutely zero tolerance for that, and I'll stand by that. So thank you for your question. I appreciate it.
Leader Lambert, you're recognized.
Thank you, Madam Chairman, and I feel like I've been taken back in time to 2017. I sat in a committee and I heard these exact same arguments. I heard passionate advocates on both sides, and I heard folks testify that the law we put in effect that would enhance the sentences on illegal immigrants that had committed crimes in this state was immediately going to be challenged. And I've been sitting up here for the last, I don't know, I guess 20 minutes where y'all been going back and forth trying to find any court that has set aside that law. I can't find one. It appears, to the best of my knowledge, that it's still in the books. So if somebody finds that, please send it to me. But there were lots of threats of lawsuits at the time. There was lots of saber rattling because we as a legislature passed a first of its kind law in the nation that said simply, if you're here illegally and you're an illegal immigrant, you are already committing a crime every day by being in a country that you did not legally immigrate into. And if you commit a crime under state law, then a judge can enhance the sentence of that individual because they have committed two crimes, not one. And again, to the best of my knowledge, that law is still in the books and being implemented every day in courts throughout Tennessee. So that's all this bill does. Now, will a court look at the proportionality of this and say, well, it's not just increasing the Senate, it's increasing it significantly? Sure, it's possible that some court could look at that, but no court has as of yet. And so appreciate you bringing the bill. The easiest way to avoid this is immigrate legally to this country, not illegally. And then for God's sakes, if you come here, don't break the law. Don't commit these type of crimes. Pretty easy to avoid it. So thanks for bringing the bill.
Leader Camper.
Thank you, Madam Chair. I think my question was answered. I was going to ask about higher ed. Was that taken out of the bill? It's just K-12?
Representative Fritz.
Thank you, Madam Chair. Yes, ma'am, Representative. It was taken out of the bill. It is K through 12 at this point in time.
Thank you.
Representative Williams. Question has been called. Hearing no objections, we are voting on House Bill 1872. Moving on to calendar and rules. All those in favor, please signify by saying aye.
Aye.
Any opposed? No. The ayes have it. If you'd like to be recorded as a no, then please see the clerk.
Thank you, Chair and Committee.
That brings us back to item number 1 on our addendum calendar. We have an amendment that is being worked on as we speak, so we're going to take a short break. And We're going to take a 5-minute break, 5-minute recess. All right, members, we are back from our recess. You should have on your dashboard a new amendment. That's what we've been working on during this break, but that is now available for you to look at on dashboard. And with that, we are back on item number 1, HB 2310 by Representative Ritchie. Do I have a motion? We have a motion and a second. Representative Ritchie, you're recognized.
Thank you, Madam Chair. I get drafting code on the new amendment is 018920.
We have a motion and a second, and that amendment does rewrite the bill. So without objection, we will vote on the amendment, and then we will ask the sponsor to explain. So we are voting on amendment 018920. All in favor, please signify by saying aye. Any opposed? The ayes have it, and the amendment is attached. Sponsor, you are now recognized to explain your bill as amended.
Thank you, Madam Chair and committee. And this particular bill provides for civil action against a person who recruits, harbors, or transports an unemancipated minor within the state for the purpose of receiving a prohibited medical procedure. And as amended, the definition is a parent or legal guardian of an unemancipated minor who is authorized to make healthcare decisions for the unemancipated minor. And with that, I stand by for any questions.
And members, that is the change that was made between the bill as it was in the finance sub in here. So Representative Freeman, you're first on my list.
Thank you, Madam Chair. And I've got a couple of questions. I just want to understand, because this has changed so many times. What's the reason for changing deleting located and substituting who resides?
Thank you, Madam Chair. So it changed from located to who resides so that we're looking at folks that are inside of the state of Tennessee. So if individuals are recruiting, harboring, or transporting individuals inside of the state of Tennessee.
Representative Freeman.
And how is that different than located? Well, I'm not sure what you're getting at.
Representative Ritchie.
So the way that it was explained to me is if an individual who resides in the state of Tennessee, which is what it's changed over to, would be somebody who would be a Tennessee resident or who resides here. Located could be a citizen from Delaware that is commuting across the state of Tennessee from a common carrier or something of that nature.
Representative Freeman.
Yeah, thank you. Thank you, Madam Chair. And the second question is, as I'm looking through the bill, it talks about intentionally recruit. And I believe you defined it in the last committee. Can you do that again? And then I've got a couple of follow-up questions.
Representative Ritchie.
Yeah, absolutely. So the word recruit, actively or knowingly to persuade or induce, is what my overall intent is. Based on other case law from legal, it said the recruit means actual or attempted solicitation, enrollment, encouragement, or effort to influence in any other way, either directly or indirectly through a third party.
Representative Freeman.
Thank you, Madam Chair. And how would that be viewed on a website that is talking about gender affirming care? If a pop-up ad came up after a search, how would that work?
Representative Ritchie.
Thank you, Madam Chair. So if the website is attempting solicitation, enrollment, encouragement, or effort to influence in any other way, then that would be, based off this bill, an act of recruitment.
Representative Freeman.
Thank you, Madam Chair. And you keep using the word encourage. How do you intend for that to be interpreted?
Representative Ritchie.
If somebody is contacting one of our minors, whether it's via social media, website, text, snail mail, putting clouds up in the sky, with the intent to encourage them to do a procedure that is prohibited by state law without that parent's consent, that would be grounds for civil action based on this bill.
Representative Freeman.
Thanks. Last question. I guess, I mean, this is now, is this your third amendment that you've done in the last 2 days of session? This seems like it needs quite a bit of work. And with that, I make a motion to send this to a summer study.
It's proper motion, properly seconded. We are voting on, without objection, we are voting on the motion to send this to summer study. All in favor, please signify by saying aye.
Aye.
Any opposed?
No.
The noes have it. We are back on the bill. Next on my list is Representative Love.
Thank you, Madam Chair. Initially, my question was really about I couldn't see some of the amendment. And so,
Are you able, it is on,
no, I mean, I couldn't, it's shadowy, but I got it now.
right. I apologize. We're,
Not a problem.
we're sort of working,
Yes, ma'am.
you know,
That
without
was
some
mine.
normal technological aspects that we usually have access to.
And that's why I raised my hand so early. I was trying to, but I got it. Thank you.
Leader Camper.
Thank you, Madam Chair. Meant to ask you this earlier, I'm sorry. And I don't know if this is addressed in the amendment I was reading. Does this also, if a doctor or healthcare provider provide them information, would that be a part of this? Would that constitute recruiting, I should say, if they're just giving them information?
Representative Ritchie.
So the overall intent of this is if a doctor is providing a diagnosis or anything, that would not be a recruitment, if that's what you're asking. If they're providing about services that are available outside of the state, then that, in my opinion, would be if they're providing, hey, here, where they're trying to encourage them to go somewhere else. But if they're providing a medical diagnosis, that's not the intent.
That answers my question. Thank you.
Chairman Zachary.
Thank you, Madam Chair. Sponsor, thank you for bringing the bill. I feel like we're missing the core issue here. Tell me if I'm wrong. Is this not a parental rights bill to protect the rights of parents making the best decisions possible, or guardians, for their children?
Representative Ritchie.
Thank you, Madam Chair. And thank you, Chairman. Yeah, correct. This right here, 100% is to protect our parents and guardians so that they have decisions on medical care and procedures that are being conducted.
One more, Madam Chair.
Chairman Zachary.
Thank you. And thank you again for the answer and for bringing the bill. I find it, when we start digging into the weeds on bills like this, 10 years ago, I think Leader Lambert referenced this in the last bill. 10 years ago, we would have never had this conversation because people would have thought it would be absurd for us to pass a bill to ensure that a minor wasn't taken against the parent or guardian's permission for some procedure. You take out the trans issue or transition surgery, replace this with a friggin' broken arm or any other medical procedure, and we would think it's absurd. Of course you can't do that without the parent's permission. My wife is a teacher, and she literally could not get a child treated last year for a broken arm without the parent's permission. But somehow we're arguing over whether it's okay for an adult without the parents or guardian's permission to take a minor for a gender transition surgery. Man, thank you for bringing the bill. It's unfortunate that we're having to pass common sense legislation in 2024 that 10 years ago, when I first started in this body, we'd have never had to consider. So thank you for having the willingness to bring the bill.
Chairman Williams. Question has been called. I see no objection. We are voting on House Bill 2310 as amended. All in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. If you'd like to be recorded as a no, then please see the clerk. That does complete our calendar for today. Chairman Zachary, you're recognized.
Thank you, Madam Chair. Members, calendar and rules will meet, so we'll say at 11:45. They need just a few minutes to put the calendars together. So calendar and rules will meet at 11:45. Thank you, Madam Chair.
Chairman Williams.
Thank you, Chair Lady. Just want to take a moment to thank our staff again. It is a very difficult job, particularly when you have late filed amendments, to be able to technologically get things to the dashboard. The only opportunity we had, so that the body knows and those listening, is to take a photo of the actual language of the amendment. I don't know if you can do this with your own kids, but sometimes shadows get in the way. But I just want to say I really appreciate the staff and their diligence and their hard work, given the fact that the train's moving really fast and they're able to be so nimble and make sure the public and this body gets the information they need. Thank you.
Well said. Without objection, I see no further business and we stand in recess.